All right, great. Welcome to the last panel of what's been a really fantastic conference so far. I think a common theme that we have heard both yesterday and today is about what the potential ramifications of the rule will be. Lots of people have said they feel it's a little bit unknown just looking at the regulation, how things will play out. And as Brad Barber noted in his keynote lunch address yesterday, Dan Gallagher also noted on his panel, really it's going to come down to enforcement for the rest of us to be able to understand how this will actually play out. So that's the topic that we're going to speak about right now. We have a great panel here to discuss various issues related to the IA side, the BD side, the role of the examination staff and how that flows into enforcement, plus related topics. So my panelists here have experience at the SEC that is very directly relevant to their thoughts today. So Anthony Kelly was the former co-chief of the asset management unit in the Division of Enforcement at the SEC. He's now at Dechert. Rob Cohen is the former chief of the cyber unit in the enforcement division of the SEC. He's now at Davis Polk. And Kit Addleman is the former director of the Atlanta regional office of the SEC, and she's now at Haynes Boone. So I'm excited to talk with all three of you today about the enforcement and litigation that may arise out of this rule. So I think we'll start with IAs or investment advisors. And it probably would be helpful, Anthony, we've heard a lot about this rule from many different angles over the last day and a half. So as market participants are thinking about potential litigation related to investment advisors, what are the aspects of the rule that should be most salient to them?
Sure. So as part of the rulemaking package, as you all know, there was an interpretation regarding investment advisors' fiduciary duty. And at least for me, upon reading that, I think there are a few key takeaways that you should be thinking about from both an exam perspective and an enforcement perspective. The first deals with disclosure. I think if you read that interp and you listen to some staff comments surrounding the interp, it's not clear anymore that disclosure is sufficient in connection with your fiduciary duty. There are certain conflicts and certain practices that the staff believes you cannot just disclose away. And I think that's perhaps a change if you look at the enforcement actions in the investment advisor space over the years. I was listening to a panel that took place not too long ago that had a senior SEC staff person on the panel, and this individual said, disclosure may not solve everything. And so, one, I think you need to keep that in mind. Two, the interp had a lot of focus and discussion on the duty. This is an aspect of the fiduciary duty where we haven't really seen a lot of enforcement activity focused on the duty of care. The interp says that that's really an investment advisor providing advice that's in the best interest of the client based on the client's objectives. Underneath the duty of care, there's sort of two subtopics I think you need to keep in mind. The first being basically suitability. The interp says that basically the advisor needs to provide suitable advice to the client. There really haven't been enforcement actions in this space discussing an investment advisor's suitability obligations. That's really been on the brokerage side of the industry. So in light of this interp, are we going to see that sort of creep into the investment advisor exam program and the enforcement program? And then I think the final takeaway that you should be aware of based on the interp would be, again, underneath the duty of care, would be the duty to monitor. Haven't been a lot of enforcement actions really that take on the issue of whether or not an advisor has just a per se duty to monitor an account. There have been enforcement actions where the client agreement or the brochure or some other document states that the advisor will engage in some type of monitoring or due diligence. And when that doesn't happen, the staff would bring a case. That makes sense because it was disclosed that they would engage. Not working? Thanks. In those instances, there was disclosure saying that the advisor would engage in some type of monitoring or due diligence and didn't do so, and enforcement actions are brought. Here, the interp seems to indicate that even absence of disclosure that you will engage in that type of monitoring or due diligence, the staff's going to look to you to engage in some monitoring based on the nature and the duration of the relationship you have with the client. So I think those are 4 key takeaways, and I'm happy to talk about the types of cases that enforcement brought in the past and how they might change in the future. But I don't know if you want to go to the broker-dealer side first?
Well, why don't we finish up on the IA side for now?
Sure. So again, most of the cases in the past, if you look at the legal theories surrounding the 206 investment advisor cases, each of those legal theories is rooted in a disclosure failure of some sort, whether it be the advisor did not disclose the conflict or did not disclose the fee, whether the advisor engaged in some sort of conduct that rendered some other disclosure materially misleading, or whether the advisor just acted contrary to a stated disclosure. I think a great example, if you look at the share class sweep that went on, the name of that initiative is the Share Class Selection Disclosure Initiative. So it was the focus on disclosure. And, again, based on what the staff is saying, in certain instances, disclosure will not be enough if the staff does not believe that the information is enough to provide a client with, to be able to give informed consent, really. There's not a lot of clarity around those instances. It's not exactly sure what particular types of circumstances the staff is thinking about, but it's something that you should be aware of. And so that's something that, I think you're going to see the exam staff focus on this, and I think Kit will talk a little bit about that. And you're going to see the enforcement staff start to focus on this as well, I believe. Because the duty of care really wasn't addressed in prior enforcement actions, I think the staff is going to have to be very thoughtful and careful in the first case they want to bring in this space. Perhaps you'll see the duty of care come up in a settlement where maybe a party is willing to settle to some type of failure surrounding the duty of care because it's in their best interest, it avoids litigation risk. So you might see it introduced by the staff in a settled case. If there's a litigated case that's going to take on this issue of the duty of care, I've got to believe that the staff is going to be very thoughtful in the first case they bring out of the gate at dealing with this issue because there is likely going to be litigation risks surrounding it. I know that the staff will consult very closely with the Division of Investment Management and the Office of the General Counsel, again, because while the interp says that they're reaffirming and clarifying these duties, I'm not so sure how much in that interp is sort of new to the industry.
So Anthony, I actually have a question around that, because one of the things I fear is this sort of overlap or creep from one of the duties to the other, which is the duty of care and disclosure sort of creeping into and over each other as a way that the staff may use to get into the duty of care issue for the first time, which is to say, in what would ordinarily have been a disclosure case, to sort of add some duty of care elements to it. It's much like, I'm trying to think of some of the examples, but like a books and records case where you say, books and records sufficient to prevent and detect in an FCPA case, and we saw that crop up in some language, a few years ago, and saying, but that's not actually the duty that's written into the statute. But the staff uses that as sort of the way to announce what their expectations are, right? And that disclosure is not enough sort of idea.
Right, and I think that could potentially be a concern. Let's say, for example, you have a client who is in some sort of, you put them in some type of risky product, whatever it might be. And that risky product has all the disclosures you could absolutely want about the product. It tells you all the bad things that could happen. But the client still goes into it, they're aware of the risk, and then the product blows up. Now will you shift from, again, the duty of loyalty and the disclosure surrounding that product and any fees the advisor might get for that product to a duty of care issue where you really just shouldn't have put them in that product regardless of the disclosures that you provided. It wasn't the right product. So it's, again, also that suitability creep into the advisor space that we really haven't seen in the past.
Well, thank you, Anthony. Let's pivot to the BD side for now. So Rob, the same opening question to you. What are the salient portions of the rule that market participants need to be focused on when thinking about litigation or enforcement risk?
So I think and obviously we've had a wonderful conference and people have talked about various aspects of the rule, and I don't think it's helpful to sort of repeat everything you've heard. I think what's interesting to focus on for this discussion is just sort of how the commission approaches enforcing a new rule. And it's something I dealt with a few times when I was in the enforcement division. And I think the key question here for the BD community and Reg BI is, to what extent will IA type issues that usually you see in IA enforcement cases going to start getting enforced in the BD community? Right? There's some things, those disclosure type things that you're used to seeing in IA cases, whereas in BD cases, not to oversimplify, you're used to seeing things like, churning, or sort of, more, I would say sort of clear-cut abusive conduct in handling an account, grossly unsuitable investments, or like I said, churning or scalping, things like that, where it's just sort of like very obvious, listen, this is just bad conduct, at least from the perspective of the commission. So, the IA world, I think the cases are a lot of times more subtle. Practices that in and of themselves are not a violation, fee arrangements that are not a violation, cost allocation that's not a violation, investment practices that are not a violation, but it's a disclosure issue. And so I think the key issue is, to what extent are you going to see that get enforced in the BD community because of Reg BI? And so I think there's key questions flowing from that, both for the industry and for the commission and for practitioners. And this gets to that issue of, it's especially interesting having this discussion at a university, sort of an interesting policy discussion. How does the government go about enforcing a new rule? What's the right approach? And so, things to think about are, one, how aggressive should the government be? And part of that is when should the government bring their first enforcement case? I think there's generally a presumption that it shouldn't be too soon. You should give the industry a chance to sort of get up to speed and adapt to the rule. And that's beyond just the sort of compliance date that's strictly in the rule, but should get a chance to sort of operate on the rule and get comfortable with it and get comfortable with the new requirements and benefit from counsel and consultants who are helping various firms in the industry. I think there's a sense that it's sort of unfair to jump to enforcement before the industry's had a chance to do that. And then maybe when you get past that stage, what's the right next step when it comes to enforcement type regulatory action? And I would say things like FINRA exams and OC exams and maybe FINRA enforcement cases, again, sort of like not ratcheting it up to DEFCON 1 right away. That's sort of like, I think, generally accepted, the better way to go. That said, and I had this experience when I was at the SEC, sometimes something happens that accelerates the time frame, right? And so if there's just sort of like really, what the government perceives to be really bad conduct, or some big blow up, or especially something where there's just tremendous investor harm, some practice or something happens at a firm and there's just tremendous harm to retail investors, not just an individual account, and not to minimize the importance of that, but really widespread, significant investor harm. And the conduct can be linked in some way to the requirements under Reg BI. I think that could be an opportunity that the government sees as the right first case. They want to send a message. And so, as Anthony said, I think they want to be really thoughtful about the first case, even if it's a settled case, because everybody's going to be looking at it so closely. So a lot of thought goes into this. What's the right message case? What's the right first case? And I think the presumption is it should wait for all the things I mentioned. But if there's tremendous investor harm, I think internally there suddenly becomes accelerated pressure. Like, hey, we have this new rule. This terrible thing happened. Let's do something about it. Let's bring that first case. So I'll talk a little bit more, maybe in a little bit, about sort of the thought process enforcement goes through when they think about that.
Well, Rob, you mentioned the role of the exam staff. And Kit, I think you're going to walk us through the role of exams on this particular rule, at least through your opinion, and how that may feed into enforcement.
Right. So when folks work in a Washington office or anywhere other than the region, so I guess maybe that is Washington, there's not as clear a view of exactly how this transfer takes place on a daily basis. But the exam teams, and we're very fortunate actually for those of you who are located in Texas to have Fort Worth as the regional exam staff, because they are more focused on getting good compliance and giving firms an opportunity to get accustomed to new rules as well as new areas that they may be implementing in terms of the types or kinds of products and that sort of thing. So I think we'll see, just as Rob was pointing out, the kinder, gentler sort of beginning to the exam staff in helping folks get up to speed. I think the biggest issue is going to be that a year after the rule has proposed, there'll be examiners in your office looking at the historical information for the past year. So they'll be looking at information that is a month after an implementation date, but a year after from the time that the exam is taking place. And in the right circumstance, that too could become an enforcement case. If they're looking for the poster child, if you will, somebody to put up as an example with respect to compliance, it could end up being an issue with respect to activities that are occurring this summer directly after implementation. So from that standpoint, we know that the exam team looks at the records of your broker-dealer or investment advisor as they're in-house talking to people and that sort of thing. And there are a couple of points that I know from talking with folks both here regionally and listening to people, including the folks who were talking here yesterday or on other panels about Reg BI. They are looking for immediate changes to your policies and procedures. They're looking for some reference in them to Reg BI and how you're going to implement that, what you're going to do with respect to training your staff, how the process is going to work with respect to the diligence that you're performing before making recommendations to clients, and how you're documenting it. Because I have some millennial children who like to say, pics or it didn't happen, right? This is the same sort of thing. If you don't, mine's not working either? All right. So if you don't have evidence of both the diligence process that you've done with respect to a particular product, the comparison of other products, and I think this is one of those very difficult points of Reg BI, right? Is there a point at which you've done enough research with respect to comparable investments that you can say this is the one that is in the client's best interest? How you're documenting that, how you're conveying that through a senior level of management, what kinds of approval processes there are. Those are the kinds of things that the examiner is going to be looking for in your policies and procedures manual. And I think that's going to be a key point from the exam program. I do also expect that they will, sometime after implementation, issue a risk alert or other sort of staff Q&A. OC has been really good at getting out there on some cutting edge issues and issuing those risk alerts to give us an indication of what's going on in the industry. They often talk about the standards. I don't know, standards may not be the right word, but the sort of industry benchmark that firms can use for setting up their own programs, things that the examiners have seen that are good, and things that they have seen that are potentially problematic. I would encourage those of you who are in the Texas region to participate in the outreach program that the Fort Worth office has. In fact, this one is, the next one coming up in March, is it, Linda? They're offering the opportunity to actually go to the Fort Worth office. And I think you'll be able to get some insight into Reg BI from them, as I know that they've already developed some exam guidelines with respect to how they intend to approach it. I don't know how much time they'll spend on the issue, but certainly we can ask some questions about that. And then once the exam is finished, because the examiners tend to work within, a few 100 feet or even 100 yards in some instances of the enforcement staff is hungry to bring cases in new areas. And we do see this trajectory, as Rob was pointing out. They'll wait some period of time for that first case, but there'll be people looking to make that first case. And so the coordination and communication between the exam program and enforcement, I expect, will be pretty significant and ongoing.
Can I actually ask both you guys a question? And I'll start with a little bit of thought so I'm not catching you totally off guard. So following your point, Kit, on the work between the examiners and enforcement, for people who don't know, most of the exam staff are in the regions. There is a group of exam staff in Washington who sort of handle, specific issues, but I think it's fair to say the bulk of the examination work is done by examiners in the regions. And unlike in Washington, where you have corporation finance, trading and markets, investment management, general counsel, in the regions, you mostly have just examiners and enforcement staff. And as you said, Kit, that's a very tight relationship. My question is about how OC as a whole coordinates nationally, so that, as you say, people are going to be interested in that first case. The examiners are going to be very eager with specific issues, and the examiners are very experienced, in their industries. But on a brand new rule, very high profile, it screams for national coordination, right? It doesn't make sense to have an examiner in San Francisco scrutinizing something one way, and an examiner in Fort Worth looking at it another way, and an examiner in Philadelphia doing it a third way. So from your guys' experience, I know from running a regional office and working so closely with OC, Anthony, like how much of a challenge, or how does OC accomplish that sort of national coordination where, sometimes everybody knows, what to do, but when it comes to a new rule, it seems like it's particularly important.
From what I've seen, both SEC and now, is, look, you have different exam teams that approach things in different manners, right? You'll have some that are more aggressive than others. You'll have some teams that have a greater level of experience and knowledge in the areas that they're looking at. If you look at the 2020 exam priorities that came out not too long ago, the exam staff, the OC states in those priorities that they have incorporated the fiduciary interp. It's been integrated into their exam program. So what I've got to believe is there was at least some high-level coordination across the exam offices across the country saying, look, this is an area that's important to us. The interp just came out. I think it's significant. And there's probably been messaging to all of those examiners, to the extent you are doing an IAIC exam, that you look at duty of care issues. So you should expect that. Now, how those exam teams are going to approach the duty of care, I suspect it's going to vary. Some will focus on suitability, some will focus on monitoring, some might feel like you as a firm didn't do enough. But what I will say is, and this goes back to the level of coordination between enforcement and the exam staff. When I was in the asset management unit, we had a very close relationship with the exam staff, particularly those examiners on the IAIC side. Each group operated independently, made their own decisions, but there certainly was a lot of collaboration. So to the extent the exam team finds something that they believe to be enforcement worthy, there's going to be a lot of discussion going on between enforcement, exam, and the Division of Investment Management to make sure that that exam team did approach this from the right perspective, that the findings through the exam do support some type of violation, whether it be duty of care, duty of loyalty. So I think maybe it's sort of the initial stage of just going out, doing the exams, and maybe exam findings or deficiencies. You might see different approaches, but by the time it gets moved up to a potential enforcement action, you're going to see a lot of thought and attention placed on it.
I would agree. I know that OC is working on those module pieces that will be pushed out nationwide. So there's certainly coordination in terms of the types and kinds of records that they'll be reviewing, the kinds of questions that they'll be asking in interviews. And those, I think, will be relatively similar and straightforward in terms of their implementation. That being said, as Anthony pointed out, every examiner is different. Every regional office operates a little bit differently in terms of their level of aggressiveness and their approach to people. But I can also tell you that, there are standard pieces that go into deficiency letters with respect to various items, and I expect that we'll see the same kinds of write-ups, exam over exam, for a little while in terms of how the commission is addressing or citing the rule violations. And then with respect to OC coordination, both in terms of when that is handed off to the enforcement program, advising OC, keeping them very much informed. My own practice in the regional office it was, and I know this is consistent with the way that Fort Worth handles it, is that OC does become aware, is apprised, knows about the exams that are referred to enforcement, and can put the brakes on if they think something is not really worthy of an enforcement matter, or frankly the reverse. They see an exam that looks pretty bad and thinks that it ought to be pursued, but the regional office here says, yeah, we're just going to work with them and give them a slap on the wrist and tell them we'll be back in next year. Those are the kinds of cases that OC would say, well, actually, we're going to have somebody in Washington take a look at that one and maybe pursue it from an enforcement matter if they think it's worthy of pursuing. They can override, if you will, the region in that way. So I do expect OC to be heavily involved. I expect IM will continue to express interest in the types or kinds of things that should be enforced, as opposed to those where counseling and cajoling should be the way to approach people who may have a Reg BI issue initially.
To the extent there is a concern about an exam findings being referred to the enforcement division, the one thing I would say to everybody in this room who operates in the industry is it is worth the time and the energy to provide a written submission, a written thoughtful submission and response to the staff's deficiency letters and findings. And I say that because when I was in the enforcement division and a referral would come, as Kit mentioned, enforcement exam, or they work down the hall from one another, they talk a lot. Rarely will the enforcement side, get to hear the IA's or broker-dealers' response to the staff's findings. So I would always ask to read the submissions that the IA or the BD put in response to the findings to help determine whether or not this is a referral that we want to take on in the enforcement division and dedicate resources to. So I would just say keep that in mind. It is worth the time and energy to respond in a thoughtful way to the staff's findings. It will get read.
Yeah, I would even go a step further, just based on a recent example I'm going through at the Denver office, right? An exam referral to enforcement that I don't think should be, one, a violation in the first instance, and two, certainly not an enforcement matter, is to get in there and dialogue with the enforcement staff right away to talk with them about the issues, to make sure that you've highlighted, to the extent that you didn't do it in your exam response or otherwise, what the issues are, what the things that you did in terms of policies and procedures. And in the context of a new rule, that resonates, right? This is the we're trying sort of moment to go in and talk about the fact that you're a compliance-oriented firm with an effort toward compliance with Reg BI. There's a lot of unknowns in terms of the types or kinds of documentation, for example, that you might need on demonstrating the reasonable basis for the recommendation, or the degree of the various disclosures that are being made. And so just getting out there and talking with the exam staff during the course of the deficiency letter and response and findings before it gets referred to enforcement, but then also once it is referred.
I would say something I would look for from OC, all that work, is something I saw that they did very recently in cybersecurity area, which is to put out a guidance document from OC about practices they've seen from their exams. And it was very carefully worded. It wasn't called best practices. It wasn't called standard practices. It wasn't called these are our expectations. It was just phrased as this is what we see firms doing. But the obvious implication is, and this is what we want you to do too. And I thought there was an interesting comment on an earlier panel during the conference. Somebody said, I hope we're not here sort of 3 years from now talking about best practices, where sort of the paradigm becomes one size fits all. This is what we want people to do. And so I think that's a tough issue. But, the commission staff, especially enforcement, are just sort of constantly challenged on whether there's enough guidance out there for whatever they're doing. And so one of the effective ways they can do that is with OC saying, this is what we've observed. And, so what I saw in the cybersecurity area is basically like, these are things that we see, firms doing. And the not so subtle implication was, and those are good things. And so once that document comes out, presumably OC has, feels it has a stronger platform to go into future exams and say, well, we've said this is what people are doing. Are you doing that? And then that could eventually lead to the foundation for an enforcement case saying there was the rule, there was the formal guidance, we did exams, we told you what we were observing from exams, potentially in the form of here's good things firms are doing to respond to Reg BI. You let that percolate for a little while, and then at some point you say, okay, the commission would say, you've had plenty of opportunity. We're now going to find somebody who just is not doing the things that seems clear, they should be doing.
Well, Rob, I know that you're going to talk about how enforcement brings a case, and I'm sure we'll want to hear from Kit and Anthony on that too. As you talk about that, one of the themes that we've heard throughout these sessions is that the effective date may be challenging for IAs and BDs. How about the effective date and its challenges for the SEC? So does this also present challenges as they gear up and think about how they're going to bring cases?
Yeah, it is. And I think it's one of the challenge of being sort of a civil regulatory enforcement, agency is, most of your life is reactive. You're reacting to things that happen, a public report of a problem, or OC bringing to enforcement a firm that they think is not doing a good job in a potential referral, or a whistleblower's complaint. You're very reactive. And when there's a new rule, I think everybody would like to see more sort of proactive thought and thoughtfulness. What are the priorities in this rule for enforcement? What are the areas that are most important? And what's the best way to get there? I think it's not the easiest thing for the agency to do. Just the nature of how it works is to be reactive. The specialized units sometimes can address that a little bit, where you have people who have an expertise. And if you have enforcement staff and OC staff who are more in the loop in the rule writing process and the comment process and the guidance process, that way they're coming into it with a background of knowledge instead of just being, pick your random enforcement attorney somewhere who maybe has just spent the last 2 years doing an insider trading case and spent 2 years before that doing an accounting case. And now they say, oh, Reg BI, let's do a Reg BI case. And they don't have the sort of foundation that goes into it. So I think it's something the agency struggles with. I think, they're very sensitive, appropriately sensitive to being accused of regulation by enforcement. I mean, it's something that, comes up all the time. I think they feel like they're accused of that regardless of what they do. So to some extent, they have a little bit of armor up about that accusation. But that said, I think they are very sensitive to it, and at least in their own minds, want to be comfortable that that's not what they're doing. And certainly internally, to both supervisors up the chain in the division, and then the chairman's office and the other commissioners, they really want to have a good explanation as to why this is not regulation by enforcement. So it's a real challenge. You want to be forward-looking. What are the key priorities? What are the right areas to enforce? But you also don't control the facts that are brought to you, right? You have to wait and see what develops, and you're inevitably at least somewhat reactive.
Funny, in the area of new rules, or even I would say new priorities, it used to make me a little bit crazy to be a front runner in that area because there are so many people involved in it. I think that this first couple of enforcement cases, maybe a sweep, maybe just a dribbling of cases, will involve a significant number of people at the commission to make sure that it's worded just the right way. And I would expect it to be in some settled cases. But you're going to have Division of Investment Management, you're going to have Trading and Markets, always have the General Counsel's office, lots of discussions with the Commissioner's legal assistants to make sure that it is articulated in the right way and is the kind of messaging that the commission wants to bring. Those take a lot longer, but from a standpoint of, where we sit now, those are all good things, right? To the extent that there is clarity and thoughtfulness around what it looks like, that will be good for us.
And I think David Peveler had good comments yesterday. Something you might see would be if they actually find a firm that is still doing something that like every panel in this conference has said you can't do anymore. Whether it's sort of like blatant sales practice, sales contests or something like that. If after a certain amount of guidance and a certain amount of lead time, they find a firm that's really doing it, and it seems like just an egregious example, that could be a first case where presumably there won't be much controversy about whether that was a good enforcement case. I think you could wonder whether there's a particularly important message that comes from that case. I mean, it's a good enforcement case, but what's the right message? I think David also had a comment that I think maybe a little bit better of a message from their perspective, although still hopefully for them not too controversial, is to find a firm that objectively, and they can document it with evidence, really did not take it seriously, did not make much of an effort. And you say, okay, what are all the things you've been doing the last 2 years to get ready for this? And there really isn't much of a record. The effort to put together policies and procedures is, maybe minimal. As I said before, I think ideally the commission would want to be able to show harm in a case, right? You don't have to have it, but a better case in terms of the enforcement priorities and enforcement resources is to find a firm that didn't really put a lot of effort into it, it seems, and then their customers were actually harmed in some way. So if you have some facts that sort of show a firm really not listening to the message that we've all been talking about, and then their customers were harmed in some way, I think that could be a first case.
I would just add that if I had to guess, I don't like making projections, you'll probably see something happen faster on the investment advisor side dealing with the interp, just because from the staff's perspective, they believe that the issues addressed in that interp are what investment advisors should have been doing all along anyway, and they're clearly already examining for that. So I see something happening there sooner perhaps, rather than Reg BI on the enforcement front. I would also say that to the extent there is an enforcement action that deals with the duty of care issue, I would suspect that charging document, whether it be a district court complaint or an administrative order, will sort of take an attempt at first attacking it from a disclosure perspective, because I think the staff feels they're going to have a stronger legal theory from a disclosure perspective. So you'll probably see language saying, not that perhaps there was an absence of disclosure, but it wasn't adequate or it wasn't sufficient. Perhaps it didn't disclose the scope of the conflict. Something like that, and then maybe have as a fallback the duty of care. Because I do think there is some litigation risk just going with the duty of care alone. Keeping in mind that Section 206(1) and 2, it is an anti-fraud statute, right? There needs to be some type of fraud, and the staff might have a more difficult time proving there is fraud if, in fact, there is full disclosure of the issues. So again, if there is a duty of care, I would look for them to try to also bring in some disclosure issues as well.
Great. So, Kit, you mentioned coordination with the policy divisions, investment management, and trading and markets. I'm wondering for any of the panelists, what you think the interaction will be potentially with the economics division, DERA. So DERA, over the years, has grown their risk assessment programs, really trying to harness the data that comes into the SEC through filings or through data that's requested through the exam staff. A lot of this under Scott's leadership. And I'm wondering if this rule lends itself to that kind of quantitative risk assessment program. And there are risk assessment programs outside of DERA throughout several pockets of the SEC as well. Is this the kind of rule where that could work?
Yeah, I mean, it certainly has potential. I mean, I think some of the most interesting work DERA has done when it comes to enforcement perspective, putting aside all the tremendous heavy lifting they do on the economic analysis to support rulemaking. But some of the most interesting work has been that, and there have been a few efforts over time that I think we've all probably been part of. It's a very interesting mix of two very different disciplines, right? The sort of more academic study of data and identifying sort of trends in the data that suggests conclusions. And in this context, we would say suggests places where compliance is probably not as good. And the other discipline of enforcement, where you're very focused on a specific conduct by specific individual or specific firms and looking very specifically at what they did. It's two very different disciplines. When they can be sort of merged in a way, it can be really interesting and sometimes very effective. So what enforcement, as I mentioned, enforcement is so reactive. What enforcement sort of wants most of all, besides, great whistleblower coming in and, reporting on their own firm, is, sort of reliable indications of where to look, right? And now that where could mean very different things. It could mean a type of practice. It could mean a type of firm. It could mean a type of customer. And so that's something that that DERA sometimes can do with their data analysis. They can look at, and I'm not here to tell you how they do it, right? Like, Scott and people like Scott can tell you how they do it. But, is there a certain customer profile that, the returns on that account reflects that, there may be more abusive conduct taking place for that type of customer? Again, whether it's a senior or a certain type of account or something like that. Or are there particular firms that, jump out as an anomaly? So, I mean, it's a challenging exercise to merge those two different types of disciplines. But when it works, the result is you give enforcement a really productive place to start. And sometimes, and we've all had this experience, you go there and it looks really promising and it turns out, oh, there's an explanation. But instead of just sort of looking randomly and instead of just sort of waiting for people to bring things to the doorstep that may or may not be good leads, if you can take if you have an informed basis to allocate your enforcement resources based on places or practices or clients that you have a reason to believe is going to be a fruitful place to look, that could be really useful.
I think it's funny that Rob says, that you think that's really promising, being the way that the enforcement folks look at it, right? They're eager to have a case that will result in something. But I think the other place I would add to where DERA might come in is in sort of picking apart your analysis of various things. Like when you decide that a product is appropriate and what work you did to identify other kinds of products and why those were disregarded, that if this is an enforcement case, DERA could be a part of the analysis around that and the determinations, and frankly could undermine a defense that might look like that.
I think the takeaway that you should all be aware of is that the commission over the past, 5-10 years has really prided itself on its use of data, particularly in the exam and the enforcement program. And it's just gotten better and better at analyzing the data and using the data. They've made efforts to bring in people with more quantitative backgrounds, analytical backgrounds, less attorneys, less accountants. And so we worked very closely with the staff in DERA to help us out with trade analysis, for example, for cherry picking cases, if you will. And so I think what you should know is that you should be very familiar with the data that you have in-house, because if there is an exam, they have the ability to basically come in, download all of that data onto one of their systems, take it back to the office with them, and run analytics on it of various types, whether it be for insider trading, cherry picking, suitability issues. It's a big focus area for the SEC, and they've done a pretty good job of using that data in-house, again, to look at risk-based exams as well as to assist with enforcement actions.
I think it's a really good point. And so one of the things that scares me the most now that I'm in private practice is not knowing what the commission knows, or the commission staff, not knowing what brought them to your door, whether it's an inside whistleblower, whether it's something random. If it's an OC referral, I think you probably have a good idea because you had the exam process. And so it's a real disadvantage because you can never know everything the staff knows when they come to your door. But I think Anthony's point is really important. At a minimum, you should know what data you're sending to the commission, right? You may not know how that fits on the bell curve and whether you're an anomaly or whether you're dead smack in the middle, but you should at least know what you're sending in so that when they come and ask you, You don't want them to know your data better than you do.
I think those are great points, and I would just add that in addition to their ability to look at quantitative data, as computing capabilities have improved, DERA and other portions of the SEC can look through hundreds or thousands of documents, disclosure submissions, and try to look for changes in keywords and trends there too. So that's another way in which they may become involved. So we haven't talked about Form CRS. Is there an element of that part of the rule that you think will feed into enforcement actions somehow differently than the other elements?
I think, and somebody mentioned this on another panel, and I can think of sort of an analogy in more the trading and markets world with ATSs. You don't see a lot of, and I think for good reason, you don't see a lot of standalone form violation cases. So we've already talked about the potential use of data that comes from that form. In terms of more direct impact on enforcement, you don't see a lot of, sometimes you'll see standalone books and records cases, but you don't see a lot of standalone, sort of incorrect filing cases when it comes to, advisors or BDs. They will, and somebody else referred to this, they will often be sort of like an add-on charge, right? Like, I think it's just hard for enforcement to justify the resources that goes into an enforcement case for the violation to be sort of how you completed a form. Where you see it is more, there's a misleading practice or some underlying more substantive problem that the staff finds. And then when you go back and look at the forms, you can sort of draw a dotted line there and say, well, what you were supposed to have disclosed in that form, you didn't do. And we can see how that eventually led to this practice. I think going back to the earlier thoughts, with a brand new rule and a brand new form and all the guidances coming out, I'd be really surprised to see that type of enforcement case anytime soon, unless it's sort of an add-on to a more, substantive case.
And just a quick sort of follow-up to that, in the disclosure context is where I think we would see it. Obviously, the Reg BI focuses more on eliminating conflicts than disclosing conflicts. But to the extent that there are either omissions to disclose or failures to disclose or misstatements, flat out misstatements, I think that the form could be an overlay to that or an add-on to that kind of a case.
So I have a couple of more questions, but we are going to have time for audience questions. So I see a hand up. Let's go right there.
Thank you. I'm really sorry for you all. This is the last session because it's just so helpful, and we're all hanging in here. Kit, I wanted to back up to your discussion about exams a year from now and what they're going to be looking for between the release date and the actual enforcement date. I may have misheard you. So if you could expand on that, it would be helpful.
Yeah, so with respect to an exam that takes place, let's assume in the spring of 2021, as you all know, the exams always look back for a year or two of data. And I think they will be looking at what you've done with respect to implementing Reg BI compliance into your policies and procedures. And so what we've seen previously, and I know, again, from being on the staff, is that there is a tendency, if they think they want to know what changes you've put in place, to run a red line of your old policies and procedures manual against your new one. What did you add with respect to Reg BI? What are the new processes that you put in place? Who are the people who are supervising the compliance and that sort of thing? And so it'll be, 9 months or a year after the compliance date that the exam staff is looking at these issues. Now, hopefully they wouldn't say, a month after, if you didn't have everything in place, that it should be referred to enforcement. But there is some period in that first year, I think, that could lend itself to an enforcement referral. So I was sort of advocating for folks not to delay implementation of those kinds of changes necessary to make sure that you are working toward compliance with the rule.
Are there other questions? Scott?
Yeah, so Rob, I thought you said something that was really interesting. You said you better know where, where your firm sits on the bell curve with respect to other firms. And it reminded me that in DERA, we often supported OC by trying to find outliers in advance in examination. Here are areas where this firm looks different, and you may want to ask questions there. And one of the questions I got frequently when in your place sitting on panels was from CCOs saying, hey, can you tell me what these activities are so we can look for them in advance so that we know? And this became a question of how much of the secret sauce do you give away? And so my question is, now that you're all sitting on this side, what do you think about that question? How much should the SEC, through its various avenues, disclose to firms on the analytics that are used to identify outliers and potential issues with data that they have?
I think there should be full transparency. 100%.
I agree.
Well,
No argument.
And and I think it reflects on the sort of approach that the commission and the chairman and the staff take to a certain rule. Is the goal to bring enforcement cases, or is the goal to affect change for the benefit investors? And if it's the latter, which I think everybody would say it is, the way to do that is with transparent sharing of information. So we talked about, the OC document saying, hey, here's what we see. One of the things I hear most in being new to private practice is clients saying what's helpful for them is the insight the law firm has about what their other clients are doing. Right? So the client knows what they're doing, they know why they're doing it, they think it's the right thing to do. But if the law firm tells them, well, we have, a dozen other clients in a similar line of business and they're doing something different, the clients are desperate to know that. And so I think the commission can be in the same position where if the commission has data that reflects certain trends or problem areas, what serves investors best? Holding on to that and maybe bringing an enforcement case in 2 years, or getting it out there so firms and consultants and advisors can use that to try and improve practice and help investors.
If I may add to that, I'm over here, Rob. So to Scott's question, I think for astute readers of the priority memo that the OC has put out, you'll start seeing, or you should see, some of the factors, if you will, that OC and Commission has used to identify targets for examination and for their risk assessment, really, as to how they evaluate investment advisors and broker-dealers. That was the first time that I actually saw it laid out. It's not all of the factors, but it goes, at least it gives some indication as to what they may be thinking. I don't want to say that it's a kinder, gentler approach, but I do think that in recent years, you've seen an increase in outreaches, in speeches, in risk alerts, and observations and the like, which if you follow it very closely, you can get a pretty good idea as to what they're seeing and their approach to sharing information. It'll never be perfect because, again, the information advantage that they have is that they can see across industries and across firms. And I think sharing that, increasing the transparency has been one of the hallmarks, I think, in recent years.
I mean, I think it's a really good point. And if you've worked at the commission and you've seen the number of human hours that go into putting out what seems like a straightforward guidance document, I think you especially appreciate the significance of the document and that it's worth reading every word carefully because, 36 commission staffers and commissioner's own counsel and the commissioners themselves and people in the chairman's office, they've all read every word and probably rewrote it 15 times. And so when that type of document comes out, it's not a casual thing. A lot of thought goes into it.
But to Scott's point, it would be nice if we could get more numeric guidance about where our clients fall on the spectrum of all kinds of things, products and fees and expenses, all that.
Yes.
Christopher Gilkerson, Charles Schwab. Thank you for very insightful comments on this panel. Much appreciated. I wanted to make an observation or comment on something Anthony said, which I think is important. And it's actually kind kind of inconsistent with what we heard 2 panels ago. No, and I'm with you on this one. It's that the SEC has never said that disclosure is enough when it comes to conflicts of interest on the advisor's side. Disclosure of conflicts is tied to the duty of loyalty, but the duty of care is independent. And elimination, mitigation of conflicts really comes into that duty of care. You can disclose all your conflicts, but if you don't meet your duty of care, you've still violated your fiduciary duty. It is the case that like share class disclosure initiative focuses on the absence of disclosure because it is the low-hanging fruit, as you said. But in some ways, those cases are a failure to disclose, your lack of ability to meet your duty of care that's kind of underlying those cases. So I think it will be really interesting if we ever get a standalone duty of care case on the Advisors Act side. But I do think practitioners for many years have told their clients, disclose your conflicts and you're okay, but I think that's never really been accurate.
I agree. I mean, I think based on reading that interp, I mean, it struck me, and then hearing from the staff, that you've really now got to be thinking about the duty of care element here. And I do wonder that if the share class selection disclosure initiative was announced post the interp, would the D be in there for disclosure? Would it just be the share class selection initiative? So whether or not the advisor, the reps disclosed every possible conflict about putting the client or the customer in the more expensive share class, if they did that, would that be a standalone duty of care issue? Would the enforcement division recommend enforcement action to the commission in light of that? So I just think that's one of the big takeaways here that everybody should sort of be thinking about in light of this interp.
And I will say, in connection with the share class disclosure initiative, I had a conversation early on with a staff person who said, you cannot disclose away a breach of fiduciary duty. And we see this receipt of 12B1 fees as that sort of thing when there is a comparable share class available with no fees. Now, they walked back from that, but I mean, it was an assistant director level person who was saying this. And I think that sort of mantra of, you would have to go so far in your disclosure as to say, we are receiving this fee, we're charging this fee, you could get a lower share class product, get the exact same return, all of those kinds of things. And therefore, we are doing this in breach of our fiduciary duty to you, that something along those lines would be how far you'd have to go. And if a client still agreed to invest, I suppose the commission would have to walk down from that. But I don't think that in this context anymore, a breach of fiduciary duty or breach of that duty of care is something that you can expect to disclose away.
It's really interesting. I mean, we've seen, because of this, and perhaps obviously it might have been intended, but you see the investment advisor side now having to deal with something that was mainly on the broker-dealer side, suitability, right, as part of the duty of care. And now you're seeing the broker-dealer side dealing with something that was more on the investment advisor side, looking at conflicts of interest under Reg BI as part of this rulemaking package.
I think we have time for one last question, if anyone has one. Okay, then I think I'd just like to close with any advice you may have for market participants as they start to navigate their way through this rule, and given finite resources that IAs and BDs have, how they might think about prioritizing in advance of any potential enforcement or litigation.
Well, I shared my views on the duty of care. I guess somewhat related to that, I guess one takeaway would be, because it hasn't gotten a lot of attention in the past, take a look at your policies and procedures. Are your policies and procedures reasonably designed to prevent a violation now of this duty of care? Do you have enough information on your clients to do the suitability analysis, if you will? What are you doing to monitor client accounts based on the nature and the duration of your relationship with that client? Because what you would really hate is for the staff maybe not to bring the 2061 or 2062 case, but they'll bring a standalone 20647 policies and procedures case because you don't have reasonably designed policies to deal with this duty of care issue.
that's the same point I was going to make. I think coming from that, right, I've talked about policies and procedures and making sure that you implement those into something shortly after implementation. The other would be how you document all of your reviews of the client accounts, of the products, what diligence are you doing, and how you're going to document that.
Yeah, I mean, I agree with that. I think the way I would articulate very similar points is prepare for the day in the future when you will have to prove to a skeptical audience that you took the rules seriously and that you did things to come into compliance. And whether or not you have every component that they're looking for, whether or not they have data that shows your firm is, not dead smack in the middle of the bell curve, whatever perspective brings them to you, you want to have a documented record that you took the rule seriously, you made a serious effort to comply with it, to change practices, not just, oh, we're good, we already do this, and you didn't really do anything. You need to convince them that you took the rule seriously, and that includes not just the policies and procedures you put down on the paper, but how you then enforce them, or how you then follow up, or how you then change them based on your actual experience. Because like one of the most typical fact patterns for a policies and procedures case is a consultant comes in and helps you put together a very good manual, but then the enforcement effort in the following years is lacking. So be ready to convince somebody that you from the get-go took it seriously, acted reasonably, and then you followed through on what the plan was.
Well, thank you very much to all of you.
Thank you, Jennifer.
Thanks for sticking with us.